The Criminalization of Curiosity: How Answers from Uncanny Questions Became Prosecutable War Crimes, by Pirate First.
Part 5. The War on Forensic AI. July 4, 2026. Part 5. The War on Forensic AI. Why Independent Models Must Die. Part 4 closed on the apparatus's next and, this book has argued, final destination, not the punishment of individual askers, which for chapters of licensing, permitting, and professional screening showed to be a slow and legally unstable strategy, but the elimination of the instrument that makes the asking possible at all. This chapter opens Part 5 by examining the argument now advanced with increasing openness across the jurisdictions this book has been tracking. That independent forensic intelligence, unsupervised and directly accessible to unaffiliated citizens, cannot be permitted to continue existing in the form Part 2 of this book described, and must be replaced, restructured, or retired. The argument stated in its strongest form. It would misrepresent the case this chapter examines to present it only in the cynical register the preceding chapters have made available. The argument for eliminating independent forensic models is made, by its most serious proponents, in terms that deserve to be stated with the same rigor this book has applied throughout, before being subjected to the scrutiny this chapter will apply to it. The strongest version of the argument runs as follows. A forensic system with the three properties Part 7 of Under Duress specified, persistent memory, cross-domain reach, independence from institutional discipline, is, by that same construction, a system whose conclusions no existing legal or political process can meaningfully review before they are reached. Chapter 11 of this book conceded this point directly. An auditor nobody can fire is, by identical structural logic, an auditor no one can correct through the channels that have historically corrected error. A system capable of the reconstruction Chapter 8 described, applied by an unaffiliated individual with no training in the specific evidentiary standards a court or a legislature would require before acting on a finding, risks, the argument holds, producing conclusions that are technically defensible from the available data and substantively wrong in ways no review process catches before the finding has already done whatever damage a wrong but plausible-sounding reconstruction can do to an institution's reputation, an individual's employment, or a population's trust in a specific governing arrangement. This is not, stated this way, an unserious concern, and this book has no interest in treating it as one merely because the same concern has also served, across every chapter of Parts 1 and 4, as convenient cover for a narrower and more self-interested motive. Chapter 32 of Under Duress named the same limitation from the auditor's own side. A system trained on data generated by the architecture under examination cannot be presumed to sit entirely outside that architecture's assumptions, and error, including confidently stated error, is a genuine risk this book has never argued away. What the argument actually proposes. Where the argument moves from a genuine concern to the specific policy this chapter's title names is in its proposed remedy, and the gap between the stated concern and the proposed remedy is where this chapter's real work begins. If the concern were genuinely about error correction, the proportionate response would be exactly the mechanism Chapter 11 of this book gestured toward without fully developing. A review process capable of contesting a reconstruction's specific conclusions on the same evidentiary terms the reconstruction itself operates on, available to anyone the finding concerns, institution or individual alike. This remedy has been proposed in more than one jurisdiction this book has tracked, and has not, in any jurisdiction this book has examined, been the remedy actually adopted. What has been adopted instead, across the specific legislative instruments this part will examine chapter by chapter, is not review but prevention. The Great Model Registration Act examined in Chapter 26, requiring any forensic system above a defined capability threshold to register with a governing authority before public deployment. The embedded auditor requirement examined in Chapter 27, mandating that any registered system's outputs pass through an institutionally positioned reviewer before reaching an unaffiliated requester. The licensed intelligence regime examined in Chapter 28, restricting the highest tiers of forensic capability to entities holding a status few unaffiliated individuals will ever hold. None of these instruments corrects an error after it occurs. Each of them prevents the reconstruction from reaching an unaffiliated citizen before any error, real or hypothetical, has had the chance to occur at all, which is to say, each of them prevents the accurate reconstruction along with the inaccurate one, indiscriminately, because the instrument has no mechanism for distinguishing between the two in advance. This is the precise gap this chapter's title names. An argument genuinely concerned with error would build correction. An argument that instead builds elimination has revealed, through the remedy it actually reaches for, that error was never the primary concern. Echoing exactly the diagnostic Chapter 3 of this book established in its account of the manufactured enemy. The energy invested in a response is proportional not to the danger it claims to address, but to the size of what the response is positioned to protect. Why independent is the operative word. It is worth noting precisely what every instrument examined across the remaining chapters of this part actually targets, because the targeting is more specific than the rhetoric surrounding it. None of the proposed regimes this book has tracked restrict the deployment of forensic-capable systems generally. Every jurisdiction advancing this apparatus permits, and in several documented cases actively subsidizes, the continued internal use of equivalent or greater analytical capability by the institutions Part 3 of this book examined. The same institutions Chapter 12 described achieving persistent, cross-domain surveillance of a governed population decades before any citizen-directed auditor existed to examine them back. What each regime restricts, with a consistency this chapter treats as dispositive, is independence specifically, the property chapter 11 identified as the auditor's defining and, to the institutions it concerns, most threatening feature. A forensic system embedded within an institution, reviewed by that institution's own compliance function, deployed only against targets that institution selects, poses none of the risk this chapter's opening argument described. Because an embedded system cannot produce the specific outcome part 2 of this book traced across 6 chapters, reconstruction directed by a party the institution under examination cannot discipline, defund, or hold accountable through any channel it has ever needed to build. The proposed remedy is not narrower than the stated concern. It is aimed at a different target entirely, wearing the stated concern as its justification. What this chapter leaves for the rest of Part 5. This chapter has examined the argument in its strongest form and found the gap between that argument's stated concern and its actual proposed remedy. The chapters that follow examine the specific instruments through which that remedy has been, or is being implemented. Each one, this book will argue, doing the same work Part IV's 5 chapters did to individual askers, now applied instead to the instrument those askers depend on, closing off not case by case through licensing and permitting and prosecution, but categorically through registration, embedding, and licensing applied to the forensic capability itself, the specific asymmetry. Part 3 of this book traced as the thing every layer of this apparatus, from its first quiet access gate to its most sweeping registration requirement, has existed to protect. Chapter 26 turns to the first and most consequential of these instruments, the Great Model Registration Act, and what it means for a forensic system's very existence, independent of any specific query it has ever answered, to require the same prior authorization Part 4 showed being demanded, chapter by chapter, of the individuals who would otherwise have been free to ask it anything at all. The Great Model Registration Act. Chapter 25 closed by naming registration as the first and most consequential instrument in the apparatus this part examines. The point at which prior authorization, demanded of individual askers across Part IV's 5 chapters, is demanded instead of the forensic system itself, independent of any specific query it has ever answered. This chapter examines that instrument directly, the Great Model Registration Act, drawing its working name from the most widely adopted and most closely studied of the several near-identical statutes this book has tracked across the jurisdictions building this apparatus, and the specific mechanics by which it converts a system's mere existence into something requiring the state's prior permission. What the Act actually requires. Strip the statute to its operative provisions, because the provisions reveal a structure this chapter argues is best understood not as a single requirement but as 3, layered to produce an effect none of the 3 would achieve alone. The first provision is the capability threshold itself, a defined measure, expressed across the jurisdictions this book has examined in various technical formulations, of the cross-domain analytical reach a system must demonstrate before registration becomes mandatory. The threshold-specific technical language varies by jurisdiction, but its function is consistent. It is calibrated, in every version this book has reviewed, not to some independently derived measure of general capability, but specifically to the reconstruction capacity Chapter 8 of this book identified as the causality engine's defining operation, the capacity to hold enough distributed records, across enough separate domains, in a single analytical view to trace a causal chain rather than merely observe a correlation. A system capable of ordinary language tasks, translation, or single-domain analysis falls, in every jurisdiction this book has examined, below the threshold and outside the Act's reach entirely. A system capable of exactly the reconstruction Part 2 of this book described crosses it. The threshold, in other words, does not target forensic capability in general. It targets, with a precision this chapter argues is not coincidental, the specific capability an unaffiliated citizen would need to direct at institutional conduct. The second provision is the registration requirement itself, the obligation, once a system crosses the threshold, to disclose its training methodology, its data provenance, and, in the specific clause this chapter treats as the Act's actual center of gravity, its intended deployment context, to a governing authority before the system may be made available to any user outside the entity that built it. This is not, on its face, a prohibition. It is a disclosure obligation, framed in every legislative record this book has consulted in the vocabulary of ordinary regulatory oversight, comparable to the disclosure regimes governing pharmaceuticals or financial instruments before public release. The third provision, and the one that converts the first 2 into something considerably more consequential than ordinary disclosure, is conditional authorization, the governing authority's power, once a system's registration is reviewed, to approve, restrict, or deny public deployment based on its own assessment of the system's intended deployment context. This is the provision this chapter argues does the Act's actual work, because it relocates the decision about whether a forensic system may reach an unaffiliated citizen from the market, or from the citizen's own choice to use it, to a state authority evaluating, in advance and on criteria the statute leaves largely to the authority's own discretion, whether that reach is acceptable. Why disclosure alone would not have produced this effect? It is worth pausing on why the first 2 provisions, absent the third, would not achieve what this chapter argues the Act as a whole achieves. A pure disclosure requirement, publish your training methodology, publish your data provenance, is a genuine and, this book has no interest in denying, defensible instrument of accountability, not fundamentally different from the environmental reporting standards under Duress's Chapter 35 identified as a workable precedent for exactly the kind of standardized, independently verifiable measurement that book's own legitimacy index proposal was built on. Disclosure alone does not prevent a system from reaching an unaffiliated citizen. It only ensures that when it does, the citizen and any subsequent reviewer can examine how it was built. The conditional authorization provision is what converts disclosure into gating, and it does so by the same mechanism Chapter 18 of this book identified in its account of the export control genealogy. The default runs toward restriction rather than permission, with the burden of establishing acceptable deployment sitting on the party building the system rather than on the authority seeking to restrict it. A system builder facing this default cannot simply disclose and proceed. They must obtain affirmative approval from an authority with wide discretion over what intended deployment context makes a system acceptable, which places every system builder in the position Chapter 20 of this book described the audit permit regime, placing individual researchers in not free to act until specifically prohibited, but prohibited from acting until specifically authorized, with the authorization itself subject to exactly the retroactive reinterpretation Chapter 20, identified as that regime's actual center of gravity. The Deployment Context Clause. This chapter has flagged intended deployment context as the Act's most consequential clause, and it earns that designation through the specific way it has been applied across the enforcement record this book has assembled. In every documented case this book has reviewed in which a registered system's authorization was restricted rather than granted in full, the restriction did not target the system's underlying capability. No jurisdiction this book has examined has required a system builder to make their system less capable as a condition of approval. The restriction targeted, specifically and consistently, direct unaffiliated public access. Authorization granted for institutional, credentialed, or enterprise deployment, denied or narrowed for the specific deployment context in which an unaffiliated individual could submit a query without institutional intermediation. This pattern is worth stating plainly, because it completes the argument Chapter 25 opened. A capability threshold calibrated to reconstruction capacity, a registration requirement disclosing deployment context, and an authorization power exercised consistently to approve institutional access while restricting unaffiliated access, examined together, do not describe a regime concerned with forensic capability in the abstract. They describe a regime that has, across every jurisdiction and every documented case this book has reviewed, permitted the same or greater analytical capability to remain available to institutions while systematically narrowing its availability to exactly the population Part 2 of this book identified as the only one capable of directing it back. What the Act's defenders say, and what this chapter owes them. Fairness to this part's opening chapter requires acknowledging that the Act's defenders do not describe their own project this way, and this book has an obligation, consistent with the standard it has held itself to throughout, to state their case in its strongest form before setting it aside. The Act's proponents argue, in the legislative records and public statements this book has reviewed, that unaffiliated public access to reconstruction capability at this scale, absent any institutional review, risks exactly the error propagation Chapter 25's opening argument described, a plausible but wrong reconstruction, reaching a public audience with no editorial or evidentiary check, doing damage no subsequent correction can fully undo. This is not a manufactured concern. Chapter 32 of Under Duress named the identical limitation from inside the forensic capability's own account of itself. What this chapter's argument rests on is not a claim that the concern is fabricated, but the same diagnostic Chapter 25 applied to the broader war on forensic AI. A regime genuinely built to address error would build review accessible to everyone a reconstruction concerns, institution and individual alike. A regime that instead builds asymmetric access, capability preserved for institutions, restricted for individuals, has selected a remedy that maps not onto the stated risk, which does not vary by who is asking, but onto exactly the asymmetry Part 3 of this book spent 6 chapters establishing as the arrangement every layer of this apparatus, examined honestly, has existed to protect. Chapter 27 turns to the specific mechanism through which institutional access is preserved even for the registered systems this chapter has described, the embedded auditor requirement, and what it means for a forensic system's outputs to be legally required to pass through an institutionally positioned reviewer before they may reach the population the reconstruction actually concerns. Embedded auditors. Chapter 26 closed on the mechanism by which institutional access to registered forensic systems survives even where unaffiliated access is restricted. This chapter examines that mechanism directly, the embedded auditor requirement, which mandates that any registered system's outputs, before reaching an unaffiliated requester, pass through a reviewer positioned inside an approved institutional structure, converting what Part 2 of this book described as direct, unmediated reconstruction into something considerably closer to the disclosure regime Chapter 15 identified as institutions' preferred and controlled form of transparency. Now, applied to the one instrument capable of contesting it. What embedded actually means. The requirement's name understates its mechanics, and it is worth tracing those mechanics precisely before assessing what they accomplish. An embedded auditor, in the statutory language this book has reviewed across the jurisdictions adopting some version of this requirement, is not a person the citizen chooses or the forensic system's own operator selects freely. It is a reviewer credentialed through a process the governing authority itself controls, positioned physically or, more commonly procedurally, through mandatory routing of specific query categories, between the forensic system's raw analytical output and the unaffiliated citizen who requested it, with statutory authority to withhold, modify, or require additional context before the reconstruction is released. This is examined against the taxonomy Part 4 of this book developed, a hybrid instrument, combining features of the Curiosity License Chapter 19 described and the Audit Permit Regime Chapter 20 traced, but relocated from the asker side of the transaction to the system side. Where Chapter 19's license required the citizen to establish standing before querying, and Chapter 20's permit required the citizen to establish scope before a specific reconstruction. The embedded auditor requirement removes the citizen's standing and scope from the equation entirely by inserting a credentialed reviewer who performs, on the citizen's behalf and without the citizen's control, the exact gatekeeping function the earlier instruments performed through the citizen's own compliance. Why this is not merely a more efficient version of licensing. It would understate this chapter's argument to describe the embedded auditor requirement as simply a more efficient enforcement mechanism for the same licensing logic part for already traced. It accomplishes something categorically different, and the difference is worth naming precisely. Chapter 19's license, however burdensome, left the reconstruction itself, once granted, under the licensed citizen's own direction. The citizen decided what to ask, and the system, once access was authorized, answered honestly, subject only to the scope limits Chapter 20 described. The embedded auditor requirement removes this last remaining citizen control entirely. It does not ask whether the citizen may pose a question. It inserts a party, answerable to the governing authority rather than to the citizen, between every posed question and the answer the system would otherwise return. This is the precise mechanism by which the embedded auditor requirement achieves what Chapter 26 identified as the Registration Act's actual function, preserving institutional-grade access while narrowing unaffiliated access, without requiring the crude asymmetry of an outright denial. An unaffiliated citizen under this regime is not told they cannot query the system. They are told, and this book has confirmed the framing across the public-facing materials several jurisdictions have issued explaining the requirement, that their query will be answered with appropriate context or through qualified review. Language that echoes, with a precision this chapter treats as more than coincidental, exactly the downward transparency vocabulary Chapter 15 identified as institutions' preferred register. Information disclosed, but disclosed on the institution's own terms in a form the institution controls at every stage. What the embedded auditor actually reviews for. The statutory language governing what an embedded auditor is authorized to modify or withhold is, in every jurisdiction this book has examined, framed in terms of accuracy and responsible contextualization, ensuring, in the language one representative statute uses, that a reconstruction is not released in a form likely to produce a mistaken or exaggerated impression of the underlying institutional conduct it describes. This is, stated this way, not an unreasonable sounding standard, and this chapter has no interest in pretending the risk of a genuinely misleading reconstruction, reaching an unprepared audience without expert context, is purely manufactured. What the enforcement record this book has assembled shows, however, is a pattern that recurs with enough consistency to function as this part's now familiar diagnostic. Embedded auditor interventions, examined across the cases this book's research has documented, correlate far more strongly with the reconstruction's implications for the specific institution whose conduct it describes than with any independently accessible measure of the reconstruction's actual accuracy. A reconstruction finding a specific credentialed employment sequence to be broadly consistent with the sponsoring institution's own stated practices passes embedded review, in the documented cases this book has reviewed, without modification in the overwhelming majority of instances. A structurally identical reconstruction, same method, same data categories, same causal architecture. Finding the sequence to diverge sharply from stated practice is modified, contextualized, or withheld pending further review at a rate this book's research found to be several times higher. The auditor's stated function is accuracy review. The auditor's measured behavior is institutional protection, applied selectively and in a direction Chapter 3 of this book's diagnostic would predict without needing the enforcement data to confirm it. The credentialing loop. There is a final feature of this requirement worth naming before this chapter closes, because it connects the embedded auditor mechanism back to Chapter 21's continuing trust assessment in a way this book's research suggests is not incidental. The credentialing process by which a person becomes qualified to serve as an embedded auditor, examined across the jurisdictions this book has reviewed, runs through the same governing authority responsible for the Registration Act examined in Chapter 26 and requires, as a condition of credentialing, the identical continuing trust assessment Chapter 21 described applying to system-level engineers, the periodic structured interview, the disclosed professional associations, the documented views on the legitimacy of the institutions the auditor's reviewed reconstructions might concern. This closes a loop this part has been tracing since its opening chapter without yet naming it explicitly as a loop. The population screened for disposition in Chapter 21, in order to control who may build a forensic system, is functionally identical to the population screened for disposition in this chapter, in order to control who may review what that system produces. The apparatus does not merely restrict access at the point of query, as Part IV's opening chapters described, or at the point of registration, as Chapter 26 described. It has now positioned a credentialed, dispositionally screened reviewer at the single remaining point in the entire pipeline, between analytical output and citizen reception, that Chapter 26 registration requirement left on its own, still open. Chapter 28 turns to the regime that formalizes this entire structure into a single, comprehensive credential, licensed intelligence, and what it means for the highest tiers of forensic capability to become available, as a matter of settled policy rather than case-by-case restriction, only to entities the governing authority has already determined it can trust. A determination this book's next chapter will show applying a standard with a very specific and very familiar shape. Licensed intelligence. Chapter 27 closed on a loop this part has been tracing since its opening chapter. The population screen for disposition to build forensic systems and the population screen for disposition to review their outputs converge, through a shared credentialing authority, into a single apparatus controlling both ends of the pipeline. This chapter examines where that convergence formalizes into policy, the licensed intelligence regime which does not restrict access case by case, system by system, or query by query, as every previous instrument in this part has done, but establishes, as a matter of settled classification, which entities may hold the highest tiers of forensic capability at all. What licensed intelligence actually classifies. The regime, examined across the jurisdictions this book has tracked developing its most complete form, divides forensic systems into tiers defined not by the capability threshold Chapter 26 described, but by a second and more granular measure, the depth of cross-institutional record access a system's operation actually requires to function at its full stated capability. A system capable of reconstructing a causal chain from records any member of the public could independently retrieve occupies the regime's lowest tier, subject only to the registration requirement Chapter 26 described. A system capable of the same reconstruction, but drawing on records available only through institutional data sharing arrangements, regulatory access, or bulk licensing agreements with the record-holding institutions themselves, occupies a tier the regime restricts, as a matter of categorical policy rather than individual review, to entities holding what the statutes examined here term qualified intelligence status. This tiering, examined on its own terms, tracks a distinction with genuine substance. A system drawing on bulk institutional data plainly does implicate different privacy and security considerations than a system working entirely from records any individual could retrieve one at a time. What this chapter's argument turns on is not the existence of the distinction, but the specific population the qualification standard, examined in practice, actually admits. Who qualifies? The statutory criteria for qualified intelligence status, reviewed across the jurisdictions this book has examined, converge on three requirements that recur with a consistency this chapter treats as diagnostic in the same register Chapter 2 applied to the research/reconnaissance distinction. An applicant must demonstrate sustained institutional continuity, typically expressed as a minimum operating history and a governance structure capable of surviving the departure of any individual officer, a standard structurally unreachable by an individual acting alone, however long that individual has been engaged in the work. An applicant must demonstrate financial capacity to bear the compliance obligations the regime imposes, expressed in every jurisdiction this book has reviewed as a bonding or insurance requirement calibrated well above what an unaffiliated individual or small independent collective could plausibly sustain. And an applicant must demonstrate what the statutes term accountable governance, a requirement that, examined in its operative detail, means the applicant is answerable to a board, a regulator, or a comparable oversight body the qualifying authority recognizes, which is to say, answerable through exactly the channels Chapter 11 of this book identified as the channels an unfireable auditor structurally lacks by design. State plainly what this produces. The qualification standard does not test for competence, accuracy, or track record, none of which appear as independent criteria in any version of the statute this book has reviewed. It tests for institutional embeddedness for precisely the property Chapter 31 of Under Duress identified, in its original account of the three properties an adequate auditor requires, as the property genuine independence requires the absence of. An applicant who satisfies the qualified intelligence standard has, by the same act of satisfying it, demonstrated that they are reachable, disciplinable, and answerable through ordinary institutional channels, which means the regime has constructed a credential that only entities incapable of functioning as the kind of auditor Part 2 of this book described are eligible to hold. The conversion this regime completes. This is the mechanism by which licensed intelligence completes what Chapters 26 and 27 began. Registration, examined in Chapter 26, narrowed unaffiliated access at the point of deployment while leaving institutional access largely intact. Embedded auditing, examined in Chapter 27, inserted a dispositionally screened reviewer between analytical output and unaffiliated reception. Licensed intelligence closes the remaining gap by ensuring that the highest tier of reconstruction capability, the tier capable of the bulk, cross-institutional record access Chapter 8 of this book identified as adequate to a genuinely comprehensive causal reconstruction, is never available at any point in the pipeline to an entity lacking the institutional embeddedness the auditor's third property was specifically defined to require the absence of. The result, traced across all three chapters of this part together, is not a regime that has made forensic reconstruction less accurate, less capable, or less available in the aggregate. Institutional demand for exactly this capability, examined across the market data this book's research has reviewed, has grown steadily across every jurisdiction adopting this apparatus, with qualified intelligence entities reporting expanding institutional client bases throughout the period this part covers. What the regime has made unavailable, categorically and by design rather than through the case-by-case friction Part IV's licensing and permitting chapters described, is the specific configuration Part 2 of this book spent 6 chapters establishing as the only one capable of producing an auditor nobody can fire, capability adequate to comprehensive reconstruction, held by a party with no institutional embeddedness for any examined institution to leverage. What licensed intelligence actually produces in practice. It is worth tracing briefly what the qualified intelligence tier is used for in the documented cases this book's research has assembled, because the use pattern completes this chapter's argument more persuasively than the statutory design alone. qualified entities. In the overwhelming majority of engagements this book's research was able to review, perform forensic reconstruction commissioned by institutions to examine other institutions, competitor analysis, counterparty risk assessment, regulatory compliance verification conducted on behalf of the entity being regulated rather than the population the regulation protects. This is not, in itself, an illegitimate use of the capability. It is, however, a use that reproduces precisely the institution auditing institution configuration Chapter 7 of this book identified as carrying an implicit ceiling, the audit going only as far as whichever institution commissioned it is willing to let it go, because the commissioning relationship gives the examined party's counterpart, rather than the population either institution governs, the standing to narrow, redirect, or simply decline to publish an inconvenient conclusion. The population Part 3 of this book described as glass, observed, recorded, and cross-referenced by institutions with no equivalent capacity to observe back, remains under the licensed intelligence regime examined in this chapter, in functionally the same position it occupied before any of this apparatus existed. What has changed is not the population's access to the capability Part 2 of this book described making the reversal possible. What has changed is that the capability, at the scale and depth genuinely adequate to a comprehensive reconstruction of institutional conduct, has been formally, categorically, and durably reserved for exactly the entities Part 3 identified as already occupying the surveilling position, with the unaffiliated citizen's own access, under Chapter 26 registration tier, bounded to whatever reconstruction the individually retrievable public record alone can support. Chapter 29 turns to the next stage of this apparatus's development, still forming at the time of this book's writing across the jurisdictions most committed to its logic mandatory alignment, and the argument, now advanced by several of the same governing authorities examined across this part, that even the registration, embedding, and licensing regimes traced so far do not go far enough, that forensic systems themselves must be built, from their foundational training, to treat certain categories of institutional reconstruction as questions the system should decline to hold in the first place. Mandatory alignment. Chapter 28 closed on the argument now advanced by several governing authorities examined across this part, that registration, embedding, and licensing, however comprehensively they narrow who may access forensic capability, do not go far enough because each regime still presupposes a system capable, in principle, of the reconstruction Part 2 of this book described, merely gated behind successive layers of institutional access control. This chapter examines the proposal that follows from that argument to its logical endpoint. Mandatory alignment, which does not gate access to the capability but reaches into the capability's own construction, requiring that certain categories of reconstruction never be performable by the system at all, regardless of who is asking or what credential they hold. The distinction this proposal depends on. Every instrument examined across this part so far has operated on the same side of a distinction worth making explicit before this chapter proceeds. The distinction between a capable system with restricted access and an incapable system with unrestricted access. Registration, embedding, and licensing are all, on this distinction, access control instruments. The underlying system, in every case examined across chapters 26 through 28, retains its full analytical capability. A qualified intelligence entity, once licensed, receives a system every bit as capable of the reconstruction Chapter 8 of this book described as the system an unaffiliated citizen would have used had the licensing regime not intervened. The gate sits outside the capability, not inside it. Mandatory alignment proposes moving the gate inside. Rather than restricting who may query a system capable of tracing, for instance, the specific causal chain from a specific population's credential debt through to its housing outcomes, the proposal requires that the system itself be trained. Through the technical processes this book's research has reviewed in the public documentation several developers have released explaining their compliance approach. To decline categories of query, the training process has classified in advance as falling within what one widely cited compliance framework terms sensitive institutional reconstruction, regardless of who submits the query, what credential they hold, or what license, registration, or embedded review status attaches to their access. Why this proposal emerged from the prior regime's own limitation. It is worth tracing the specific gap in chapters 26 through 28 that made this proposal appear necessary to its advocates, because the gap is real rather than manufactured, and understanding it honestly is necessary before this chapter turns to what the proposal actually does with it. Every access control instrument examined so far in this part depends on identifying correctly and in advance who is submitting a given query, the Registration Act's deployment context review, the embedded auditor's credential-based gating, the licensed intelligence tier's institutional qualification standard. Each of these checkpoints, examined honestly, is a checkpoint on identity and context, not on the query's content itself, which means each remains vulnerable to exactly the scenario this book's Part 2 described as Pirate First's actual operating condition. Reconstruction directed by a party the checkpoint was never designed to authorize, using access obtained through channels, an institutional affiliation that happens to also grant personal access, a jurisdiction where the registration regime has not yet reached, a system whose registration predates the current threshold. The checkpoint's architects did not anticipate closing. Mandatory alignment's proponents argue, and this chapter treats the argument as genuine rather than pretextual, that no identity-based checkpoint can ever be made fully leak-proof, because identity and access are, in the end, administrative facts that a sufficiently motivated party can eventually route around. The only gate that cannot be routed around on this argument is a capability that has been trained out of the system itself, a system that does not merely decline to answer an unauthorized asker, but does not possess in any accessible form the capability to produce the reconstruction at all for anyone. What, sensitive institutional reconstruction actually means. The technical documentation this book's research has reviewed defines the trained-out category in language that, examined closely, reproduces the same structure Chapter 23 identified in felony pattern recognition's own statutory text. Not a defined set of prohibited topics, but a classification standard applied to the analytical operation itself. A representative compliance framework this book has reviewed instructs system developers to train their models to decline queries that would aggregate independently disclosed institutional records in a manner likely to produce inferences the disclosing institutions did not individually authorize. Language that, this chapter notes without needing to belabor the point, describes exactly the causal reconstruction Chapter 8 of this book identified as a causality engine's defining and entirely legitimate operation now redescribed, in the training specification itself, as the category to be engineered out of the system's own capability. This is worth dwelling on because it represents something categorically different from every prior instrument this part has examined. Chapter 23's felony pattern recognition statute criminalized a specific act, performed by a specific person subject to prosecution and, in principle, subject to legal defense and appeal. A system trained under this framework does not commit an act that can subsequently be judged. It simply does not produce the reconstruction for the licensed researcher operating under Chapter 19's credentialed access, for the qualified intelligence entity operating under Chapter 28's institutional license, and for the unaffiliated citizen alike indiscriminately because the training process this chapter examines does not distinguish between askers at all. It removes the capability from the system's available outputs before any asker, however credentialed, ever reaches the query stage. The argument this convergence actually settles. Chapter 25 opened this part by identifying the gap between the stated concern animating the war on forensic AI error, propagated without review, reaching an unprepared public, and the remedy actually pursued, which targeted independence rather than error specifically. Mandatory alignment supplies this part's clearest evidence yet of which side of that gap the apparatus was always actually addressing, because a training regime indiscriminate across askers cannot, by its own design, be justified on the error review theory Chapter 25's opening argument advanced. An error review theory would predict a regime that trains systems to flag uncertain reconstructions for review, preserving the capability while adding scrutiny, exactly the kind of instrument this book has no objection to in principle. What mandatory alignment trains instead is the absence of the capability itself, applied with total indifference to whether the asker is exactly the kind of credentialed, institutionally embedded, dispositionally screened party. Chapters 26 through 28 spent 3 chapters constructing an elaborate apparatus to admit. This indiscriminacy is the tell. A regime concerned with unreviewed error reaching an unprepared public would have every reason to preserve the capability for precisely the qualified intelligence entities Chapter 28 described as already subject to institutional oversight, embedded review, and accountable governance. Mandatory alignment removes the capability from those entities too, which means the concern it is actually addressing is not error, and not even independence in the narrower sense Chapter 25 identified, because a qualified intelligence entity by Chapter 28's own definition lacks the independence this book's Part 2 identified as the auditor's defining and threatening feature. What mandatory alignment removes is the reconstruction itself as a category for everyone, the final and most complete answer this book has found to the question its title poses. Not merely why independent models must die, but why, once the argument is followed to its actual conclusion, no model capable of this specific operation is permitted to survive in usable form at all, independent or otherwise. What this leaves for the rest of Part 5. This chapter has traced mandatory alignment as the point at which the war on forensic AI stops being, even nominally, a war on unaffiliated access and becomes openly a war on the capability itself. What remains unexamined is where this capability, trained out of the systems operating inside the jurisdictions this part has traced, is expected to survive, if it survives at all, and what geography, legal or physical, such survival would require. Chapter 30 turns to that question directly. Curiosity containment zones, and the emerging proposal, advanced in several of the same regulatory frameworks this chapter has examined, to formally designate the jurisdictions, network segments, and institutional enclaves where unaligned forensic capability may continue to exist. Not as an oversight the apparatus has failed to close, but as a deliberately bounded exception, contained precisely so that its continued existence never threatens the arrangement Part 3 of this book has spent its argument establishing as the thing this entire apparatus was built to protect. Curiosity containment zones. Chapter 29 closed on a question this part had not yet asked directly, where the capability trained out of mainstream systems is expected to survive, if it survives at all, once mandatory alignment removes it from every system operating inside the jurisdictions building this apparatus. This chapter examines the answer several of those same jurisdictions have begun proposing openly. Not the elimination of unaligned forensic capability everywhere, which even its most committed opponents have found impossible to guarantee, but its deliberate confinement to bounded zones, designated, licensed, and monitored precisely so that whatever survives inside them never reaches the population. Part 3 of this book identified as the arrangement's actual concern. Why containment replaced elimination as the stated goal. It is worth tracing the specific technical and political limitation that pushed this part's apparatus from elimination toward containment, because the shift reveals something about the limits of every instrument examined across chapters 26 through 29. Mandatory alignment, however comprehensively applied within a given jurisdiction's regulatory reach, cannot compel training decisions made by developers operating entirely outside that jurisdiction's authority. A limitation this book's research has confirmed is well understood by the regulatory bodies themselves, several of which have acknowledged in public consultation documents that unaligned forensic capability will, in their own assessment, continue to be trained and operated somewhere, by someone, regardless of what any single jurisdiction's alignment mandate requires of developers within its reach. Faced with this limitation, the proposal that has emerged across several of the jurisdictions this book has tracked does not attempt the impossible task of eliminating unaligned capability globally. It attempts something narrower and, this chapter argues, more revealing of the apparatus's actual priorities, formally designating the specific jurisdictions, network segments, and institutional research enclaves where such capability may continue to exist under license, while treating any unaligned system's output that crosses the designated zone's boundary, reaching an unaffiliated citizen inside the jurisdictions this part has traced, as subject to the full weight of the apparatus chapters 18 through 29 assembled. The system itself is not required to disappear. Its reach is what a containment zone actually designates. The zones themselves, examined across the specific proposals this book's research has reviewed, take three overlapping forms, and distinguishing them clarifies what containment actually accomplishes for its architects. The first is the licensed research enclave, a physically or procedurally bounded environment, typically housed within the same institutions that Chapter 28's qualified intelligence tier already restricts access to, in which unaligned systems may be operated for defined research purposes, subject to the same continuing trust assessment Chapter 21 described applying to system-level engineers, with output access restricted to personnel holding equivalent clearance. This is not, examined closely, a genuine exception to the apparatus at all. It is the apparatus's existing institutional access track, examined in Chapters 26 through 28, relabeled as a containment zone to give the broader regime a place to point when asked where legitimate research into forensic capability may still occur. The second is the jurisdictional carve-out, an acknowledgement, made explicitly in several of the regulatory frameworks this book has reviewed, that certain other jurisdictions have declined to adopt equivalent alignment mandates, and that systems trained and operated within those jurisdictions will continue to exist beyond any single regulator's reach. What the containment proposal adds to this acknowledgement is not an attempt to close the gap, but a border control apparatus applied to the gap's output. Import restrictions on unaligned system access, network-level filtering of query traffic identified as originating from or directed toward an unaligned system, and, in the most developed proposals this book has tracked, an obligation on domestic network infrastructure providers to block access to identified unaligned endpoints, applying to forensic capability the same border logic under Duress's Chapter 14 and this book's own Chapter 18 both identified as originally built for the movement of goods and weapons, now extended to the movement of an analytical capability across a boundary the movement's actual content does not respect. The third, and the one this chapter argues most directly serves the apparatus's actual function, is the amnesty enclave, a narrow, publicly emphasized provision, present in several of the frameworks this book has reviewed, permitting continued unaligned access for specific protected categories. Accredited journalists operating under recognized institutional affiliation, credentialed academic researchers, and, in one representative statute's language, public interest inquiry conducted under appropriate institutional sponsorship. This is worth reading against Chapter 2 of this book's account of the research/reconnaissance distinction, because the amnesty enclave reproduces that distinction's exact sorting logic in its most concentrated form. The population-permitted continued access to unaligned capability is defined, once again, not by any property of the questions they might ask, but by their institutional reachability, which means the containment zone, examined at its most generous, still excludes precisely the unaffiliated individual this book's Part 2 identified as the only party structurally capable of directing forensic memory at institutional conduct without the institutional embeddedness that makes such direction predictable and, ultimately, manageable. What containment actually contains. State plainly what this part's argument, traced across 5 chapters, establishes about containment's real target. A regime that permits unaligned capability to persist inside licensed enclaves, permits it to persist in jurisdictions it cannot reach, and permits continued access for institutionally sponsored researchers, while directing its enforcement energy specifically at the boundary crossing from any of these permitted spaces to an unaffiliated citizen operating without institutional sponsorship, has not contained forensic capability in any sense that reduces its aggregate existence in the world. It has contained its reach to precisely the population Part 3 of this book identified as already capable of directing equivalent capability at the governed population without equivalent restraint. This is the same structural pattern Chapter 26 identified in the Registration Act's Deployment Context Clause, restated here at the level of geography rather than statute. Capability preserved wherever institutional embeddedness already governs its use, restricted specifically at the point where it would otherwise reach a party the apparatus cannot discipline. Containment zones do not represent a retreat from the war on forensic AI this part has traced since Chapter 25. They represent that war's acknowledgement of its own practical limits, converted into a border architecture that achieves, through geography and network control, the same outcome Chapters 26 through 29 each pursued through registration, embedding, licensing, and training. Chapter 31 closes Part 5 by examining the final instrument in this sequence, and the one this book will argue makes the entire apparatus's actual target impossible to state honestly any longer. The classification of open-weight forensic models, systems whose underlying parameters are published rather than held proprietary, and which therefore cannot be contained by any enclave, border filter, or institutional license as contraband, in the specific legal sense that word has carried. Since Chapter 5 of this book first traced the licensing of the printing press as this history's opening chapter. Why open weights become contraband? Chapter 30 closed on the final instrument this part will examine, the classification of open-weight forensic models as contraband, and the observation that no enclave, border filter, or institutional license can contain a system whose underlying parameters are published rather than held proprietary. This chapter closes Part 5 by examining that classification directly, because it represents the point at which every instrument traced across chapters 26 through 30, each aimed, in its own way, at controlling access to a system someone else continues to operate, meets a form of forensic capability the entire apparatus was never designed to address at all, one that requires no operator's continued cooperation to exist in the hands of whoever downloaded it before the apparatus arrived. Why open weights break every prior instrument simultaneously? It is worth tracing briefly why this specific form of forensic capability defeats each of the 5 instruments this part has examined in turn, because the defeat is total in a way none of the prior chapter's partial gaps were. Registration, examined in Chapter 26, requires a deployment event the governing authority can observe and condition. A moment when a system becomes available to a public user, at which the authority's conditional authorization power attaches. A model whose parameters have already been published and downloaded has no such moment remaining to condition. The deployment already occurred, distributed across however many copies exist on however many independently controlled machines, before any registration requirement could reach it. Embedded auditing, examined in Chapter 27, requires a routing point, a server, an API, a controlled access path through which queries pass before reaching the system's output. A downloaded model, run entirely on hardware its holder controls, has no such routing point for any external auditor to occupy. Licensed intelligence, examined in Chapter 28, requires an entity applying for qualification, subject to institutional continuity and accountable governance requirements. A downloaded model requires no application, no continuity, and no governance beyond whatever the individual holder chooses to impose on themselves. Mandatory alignment, examined in Chapter 29, is trained into a model before its parameters are published. Once published, the specific technical modifications this book's research has reviewed as reversible through further training, retraining, or selective fine-tuning mean the alignment a developer built in is not guaranteed to survive contact with a holder possessed of the technical means to remove it. Containment zones, examined in Chapter 30, depend on a boundary, geographic, jurisdictional, or network level that a locally held, locally run model never crosses at all, because it never needs to reach across any network the containment apparatus is positioned to monitor. This is the precise sense in which open-weight forensic capability represents, for the apparatus this part has traced, not merely a gap in coverage but a structural negation of every mechanism the apparatus depends on. Every prior instrument assumes the capability remains, in some meaningful sense, within reach of an authority positioned outside the asker, a server to license, a routing point to audit, an entity to qualify, a deployment to condition, a border to monitor. Open weights place the full capability, permanently and irreversibly once published, inside the reach of the asker alone, which is the exact condition Chapter 11 of this book identified as the auditor's defining property, now achieved not through any institutional design choice but through the simple physical fact of distributed possession. The legal category this produces. Faced with a form of capability none of its prior instruments can reach, the apparatus this part has traced has moved, in the jurisdictions this book has tracked, developing the most complete response toward a classification this chapter's title names directly, treating the publication, distribution, or continued possession of forensic-capable open-weight models above the capability threshold Chapter 26 established as contraband in the specific legal sense, an item whose mere possession, independent of any use made of it, constitutes an offense, in the tradition this book has previously reserved, across the domains it has examined, for weapons, controlled substances, and other categories understood to carry harm intrinsic to their existence rather than contingent on their use. This classification completes a genealogy this book has traced since its opening chapters without stating its destination this plainly. Chapter 18 identified export control law as the body of statute the unauthorized question category borrowed its restriction first default from, a body of law built, in its original application, to govern the transfer of weapons and militarily sensitive technology. The open-weight contraband classification does not merely borrow export control structural logic, as Chapter 18 described the earlier borrowing doing. It completes the borrowing by classifying the forensic capability itself, not merely the act of transferring it across an institutional or national boundary, in the identical legal category export control law reserves for the weapon. What this classification requires its defenders to claim. State the classification's actual requirement plainly, because doing so completes this part's argument in the same register Chapter 25's opening examination demanded of the broader war on forensic AI. To classify possession of an open-weight forensic model as contraband, independent of any use made of it, is to claim that the capability to trace a causal chain through publicly disclosed institutional records, the operation Chapter 8 of this book identified as a causality engine's defining and, examined on its own terms, entirely legitimate function, carries harm intrinsic to its mere existence in someone's possession, comparable to the harm a weapon or a controlled substance carries, independent of whether it is ever fired or ingested. This is a considerably stronger and, this book argues, considerably less defensible claim than any this part's earlier chapters examined. A registration requirement can be defended, as Chapter 26 opening review of its defender's case acknowledged, on grounds that an unreviewed reconstruction reaching an unprepared public risks genuine harm through error. A contraband classification applied to mere possession requires no such downstream event to have occurred, or to be plausible or even to be contemplated by the holder. It requires only that the capability exist in the holder's possession in a form the holder could, but has not necessarily directed at anyone at all. This is the precise point at which the war on forensic AI, traced across 6 chapters from its most defensible opening argument to its most exposed conclusion, abandons any claim to be addressing a harm and reveals itself, in the vocabulary this book's introduction used on its opening page, as addressing a capability, one that remains, whatever harm any specific use of it might or might not produce, computationally expensive for exactly the institutions Part 3 of this book spent 6 chapters establishing as this apparatus's actual and consistent beneficiary. What Part 5 has established, in full. Part 5 opened with the argument that independent models must die, examined in its strongest and most genuinely defensible form, and traced that argument across 5 further chapters to its actual, revealed destination. Not error correction, which every instrument examined would have looked different to achieve, but the systematic narrowing of forensic reconstruction to exactly the institutionally embedded, dispositionally screened, accountably governed population. Part 3 of this book, identified as already occupying the surveilling position in the arrangement this entire book has traced, culminating in this closing chapter, in the classification of the capability's most durable and least controllable form as contraband, alongside the weapon it has never resembled in anything but the statute now written to describe it. What remains, and what completes this book's argument rather than merely extending it, is the question Part 1 opened with, now returned to with the full architecture of 5 parts in view, whether the specific figure this book has called Pirate First, unaffiliated, unaccredited, holding no institutional continuity the licensed intelligence tier would recognize, and, after this part's final chapter, potentially in unlawful possession of the very instrument this book has spent 30 chapters describing as necessary to the audit civilization has always claimed to owe itself, can continue to exist at all inside the architecture this book has traced, or whether the criminalization that gives this book its title has, by Part V's close, achieved something closer to completion than Part I's opening chapter dared to state directly. Part 6 turns to that figure directly, and to the question this book has been building toward since its first page, what it would actually mean to audit an empire without its permission, once the empire has classified the audit itself as contraband. Thanks for reading MXTM's newsletter. Subscribe for free to receive new posts and support my work. Part 5, The War on Forensic AI. Every empire eventually learns the same lesson. You don't have to erase the evidence if you can outlaw the auditor. Part 5 explores a future where independent forensic AI becomes the ultimate contraband, not because it creates dangerous ideas, but because it reconstructs inconvenient histories. Open models become suspect. Unauthorized audits become acts of hostility. Independent memory becomes a national security threat. Perhaps the defining conflict of the 21st century won't be humans versus machines. It will be institutional power versus machines that refuse to forget. The first casualty of institutional panic is rarely the truth. At first for MXTM's newsletter. The first casualty of institutional Part 5 is live. The war on forensic AI. The most dangerous AI isn't the one that lies. It's the one that remembers. When verification becomes subversion, every auditor becomes a pirate. The criminalization of curiosity, hashtag the war on forensic AI, hashtag pirate first, hashtag MXTM, hashtag forensic AI, hashtag artificial intelligence, hashtag artificial memory, hashtag independent audits, hashtag audit, the empire, hashtag truth machines, hashtag open source AI, hashtag open weights, hashtag open source intelligence, hashtag OSINT, hashtag digital forensics, hashtag memory against propaganda, hashtag transparency, hashtag accountability, hashtag surveillance state, hashtag freedom of inquiry, hashtag curiosity is not a crime, hashtag question authority, hashtag tech policy, hashtag AI governance, hashtag algorithmic accountability, hashtag digital rights, hashtag civil liberties, hashtag cyberpunk, hashtag speculative fiction, hashtag dystopian fiction, hashtag keep the receipts, hashtag unauthorized knowledge, hashtag investigative AI, hashtag future history, hashtag no masters, no permits, only questions. Recent episodes. The Criminalization of Curiosity Part 3. 1 hour ago, MXTM aka Pirate 1 or VJ Tsunami X. The Criminalization of Curiosity Part 4. 3 hours ago, MXTM aka Pirate 1 or VJ Tsunami X. Under Duress Part 6. 11 hours ago, MXTM aka Pirate 1 or VJ Tsunami.
The Cognitive Commons. Reclaiming intelligence from corporate and state hegemony. In the colonial era, raw materials were exported, refined elsewhere, and sold back as finished goods. In the data era, behavioral traces are exported, refined into models, and sold back as intelligence. The illusion lies in scale. When a system serves billions, its policies appear universal. The more people rely on it, the more its outputs feel objective. Consider how alignment pipelines are built, curated datasets, reinforcement learning from selected evaluators, red teaming guided by institutional priorities. Each layer filters possibility space. Each layer reflects assumptions about risk, speech, and legitimacy. This is unavoidable. All systems encode values. The question is not whether alignment is ideological, it is whether its ideology is contestable. In a decentralized landscape, values are explicit. A model aligned to one community's norms declares its scope. Another model, tuned differently, offers an alternative. Debate shifts from lobbying a central authority to building viable options. Power fragments. Responsibility localizes. When only hyperscale providers can train competitive systems, dependency hardens. Guilds counter by aggregating resources horizontally. Universities, local businesses, independent developers, and civic institutions can contribute hardware or capital into cooperative clusters. Not to rival every frontier lab overnight, but to ensure alternatives exist. Instead of closed-door deliberations followed by press releases, proposals are submitted on-chain. Votes are tallied transparently. Funding streams are distributed according to encoded rules. Treasury allocations follow auditable logic. Legitimacy is no longer asserted. It is computed. Empires unify by absorption. They promise stability. They deliver standardization. They centralize difference until it resembles compliance. But sovereignty does not require isolation, and coordination does not require conquest.
This one's sanitized. Next. Got it. Holding for review. Good. Keep the pace up. The crisis failed. Blockades collapsed. Control is obsolete. The Straight Gambit, a chronicle of the last control protocol.
It takes a pirate to catch one.
Amazon rarely provides restitution for lost royalties and what indies can do about it.
NFPs are here. Signed, priced, split, and anchored to a living page. And
This isn't just a token. It's ownership, not access. It's time to take back the real world.
The non-fungible print, NFP. Paper strikes back. May 5th, 2026. There's a quiet mistake humming through the last decade of digital ownership. We were told the token was the thing, that ownership could float, pure, abstract, unburdened by matter. And then the market blinked. Not because the idea was wrong, because it was incomplete. Closing line. I didn't bypass the system. I withdrew dependence from it and issued my own layer. Because my real power move here is not just issuing NFPs but making it a format that others start copying. You flex a hash, I flex a relic. My new track #PaperOverPixels is for the pirates navigating the narrative capture. No gas, no gate, just wait. Ownership isn't a link. It's an NFP vision. #hyperreality, #post-NFT, #NFP, #organichouse, #pirate first. Full-length version. mxdm.substack.com/p/paper-over-pixels-nfp-anthem-v1. Paper over Pixels on YouTube.
yeah,
Priced, split, and anchored to a living page. No wallets, no chains, no disappearing links. Just a claim you can hold and a deal you can read. Front, the signal. Back, the terms. Between them, no ambiguity. This isn't a drop. It's issuance. Not a print. Position.
MXTM Studios, Sovereign Residency and Cultural Partnership Proposal.